Hello, everyone. Welcome to the third Bite Size series. Good to see some faces. Clearly, we haven't we're doing something right. People are coming back for more. Um, so, what we do, quick introductions. My name is Bevzi Hussein. We've set up these Bite Size sessions to kind of acknowledge the 60th anniversary of the Race Relations Act, along with my colleague Phil Cherrington, who is Phil C, has just changed his name. Well done, Phil. Good timing.
Oh,
Um, so, yeah, I'm a policy assistant in the Quality Education and Development Department. And this session today is going to focus a little bit around, well, significantly around the Equality Act and looking at how the law on race can be applied. So a little
cool.
bit of housekeeping first. If you can put yourselves on mute, please, that would be really appreciated. Um, and there'll be an opportunity to ask some questions and make some comments and observations at the end. Okay. Good to see colleagues. Pete, welcome to the call. So, like I said, this bite-sized session is going to be looking at the Equality Act and specifically those elements that aim to give some protection, give people protection under the protected characteristic of race. And I told everyone to turn their phone off and put it on mute, and my phone just goes off. That's typical. Um, Apologies about that. Um, let's just make sure that's on mute. Okay. So I'm going to share a PowerPoint with you. Bear with me. Glad you find it funny. Okay, can you all see that? Just give me a thumbs up. Thank you. So when it comes to the Equality Act, race can mean your color or your nationality, including your citizenship. It can also mean your ethnic or national origins, which may not be the same as your current nationality. For example, you may have Chinese national origins and be living in Britain with a British passport. Um, Race also covers ethnic and racial groups. And this basically means that a group of people who all share the same protected characteristic of ethnicity or race. A racial group can be made up of two or more distinct racial groups. For example, Black Britons, Black Asians, British Sikhs, British Jews, Roman Gypsies, and Irish travellers. These are examples of a distinct racial group being made up of two or more groups, two or more identities. You may be discriminated against because of one or more aspects of your race. For example, um, people born in Britain to Jamaican parents could be discriminated against because they are British citizens or because of their Jamaican national origins. Similarly, in some circumstances, race discrimination may also be linked to religion, for example, being Muslim, Hindu, or Jewish. And such groups would also be an ethnic group covered in the ethnic origins definition. Although religion and belief is a separate protected characteristic, protection under the race discrimination provisions may exist or coexist if that group meets a specific test, which focuses on its shared history, shared descendants, and geographical origin, customs, and or beliefs. So, understanding the Equality Act in a legal context. So, in order to help you understand um, how the law can be better understood on race, um, we're going to look at possible, the way to possibly address legal issues linked to race. And I'm going to try and go through what I call a brief deconstruction of those legal layers, which I believe are relevant to this discussion. So remember, colleagues, knowledge really is power. And I know some of you already have a good understanding of the Equality Act and are already applying this effectively in your workplace to help Black and brown global majority members. Some common examples of direct race discrimination include being refused a job interview because of your surname or accent, or receiving poorer service in a shop or restaurant because of your race. I'm sure many of you have experienced that. That could potentially fall under the goods and services angle, which I'll come on to later. So many people face harassment at work due to your nationality or ethnic background. A quick example I'm going to give you of indirect discrimination. An employer gives out an instruction, a directive, and says all employees must start working some Saturdays because they're changing their opening times. This affects everyone who works for the organization. So effectively, it applies across the board. One employee is Jewish and observes the Sabbath, so they cannot go to work on a Saturday. So effectively, they are put at a disadvantage because of their ethnic group. If the employer cannot legally justify the change and the need for all employees to work on Saturdays, this would be likely to amount to indirect discrimination. So this is also known as a PCP, which is provision, criterion, or practice. And I'm going to mention certain sections of the Equality Act. So for those of you who are interested, the indirect discrimination part of the Equality Act is covered in more detail under Section 19 of the Equality Act. So this discrimination, it's one of the few areas where the employer may have what's called an objective justification argument, though an employer would need to think carefully before engaging objective justification. The definition of objective justification is as follows. Objective justification is a legal defense that allows certain types of discrimination to be lawful as it serves a legitimate aim and is proportionate. Under the Equality Act 2010, objective justification applies in only specific cases of discrimination, namely indirect, which I just gave an example of, discrimination arising from disability, which for those of you who are familiar with disability law, I believe is covered under Section 15 of the Equality Act, and direct age discrimination. Direct age discrimination is the only form of direct discrimination that can be justified this way. So, if we look at the next slide, I'm going to go into a little bit around reputational damage and why it's in the interests of an employer to play their part in applying the Equality Act in a positive way in the workplace. But I think it's fair to say that, apologies for the typo on this slide, we'll get that amended. The Equality Act protects you right from the point of when you apply for a job, at interviews, and to the point when you leave, even after you've left. Because if you have an ongoing issue and there's a poorly written reference, potentially there could be some calls for legal redress by the individual concerned. So on the angle that I want to touch on in terms of why it's in the employer's interests to play fair on race and generally across all the different strands under the Equality Act 2010. What can be the extent of reputational damage in terms of, if the Equality Act isn't applied properly, when people face discrimination in the workplace or in a shop under goods and services? We know that that there's reputational damage issues for the employer potentially. You get hauled before an employment tribunal if the person goes to an ET. It becomes a matter of public knowledge unless there's restrictions in place. There's damage to the morale of workers. There's significant cost in terms of both money and time and energy, not just for the employer, but there's massive impact on the individual. And if we look at the single biggest reputational damage slur on race that any employer has faced in the last 50 years, can anyone think what scenario that might be? It's a scenario that we've actually touched on in previous bite-sized sessions. And I'll draw your attention to the Macpherson report in the wake of the murder of Stephen Lawrence. And the Macpherson report labelled the Metropolitan Police as institutionally racist. You can't get a more damning reputational damage statement than that. That murder and that report and that the institutional racist statement has been, it's been in place and since 93, 94. And really that label is stuck. And despite the good intentions of some police commissioners of late, that label is going to stick around for the foreseeable future. In terms of I touched on the cost aspect. You'd be interested to know the highest ever payout at an employment tribunal involved the case of Dr. Eva Michalak. I hope I've said the surname right. She was awarded 4.5 million in compensation back in 2010. So over about 14 years ago, after she won her claim for, it was a combination of complaints. She had unfair dismissal and sex and race discrimination. The case was against the NHS trust that she worked for. Now, Mrs. Michalak was subjected to what her legal representative described as a Get Eva campaign following her return to work from maternity leave and her subsequent request to receive the same pay as her colleagues. So there was an equal pay angle to this case. But interestingly, I think it's important that people are realistic on these types of claims, because when you consider the colossal level of compensation that was paid to Mrs. Michalak, £4.5 million, how much of that was what's called injury to feelings? Which some of you will be aware is the aspect paid around the discrimination. Of that figure, only 30,000 was the injury to feelings, which is really interesting. And that is kind of at the top end of what's known as the middle band of Vento. And just very quickly on Vento, like I said, calculates the level of compensation that someone could be entitled to. It's always a very difficult conversation with an individual once someone's has gone through discrimination. To effectively put a price on that discrimination is tough. But the lower band starts at 1,000 and goes up to 11,700. The middle band goes up to just over 35,000, and the higher band goes up to nearly 59,000. It's 58,700. And in the most serious cases, there's no actual ceiling in place on injury to feelings. And the Michalak case is interesting because her case showed that she had suicidal thoughts because of how she was treated. And yet the judge felt her claim fell into the middle band. So that's always a good marker for you to have a think when you have these conversations around what is my case worth. And the average award for race claims in the last year was just over 20 3,000, which again, obviously depending on what your salary is, when there's loss of earnings, pension losses, this is when the figures really begin to step up. So I touched on goods and services, and what I want to mention is that's covered under Section 28 of the Equality Act. Okay, apologies for the spinny annotation. I'll give you a quick example of goods and services. There's a case where a couple was awarded £2,500, and again, a little bit of a trigger warning because some of the commentary around this isn't pleasant. Couple were awarded £2,500 in compensation after they suffered racial discrimination at the hands of a car sales company. Kin Hung Wong was a man of Chinese descent, and his wife was a Hong Kong national. They visited John Mulholland Motors to buy a new car. Wong conducted all negotiations with staff in English, his first language. However, when he had to explain certain aspects of the sale to his wife, he switched to Cantonese, which was her mother tongue. And this didn't go down too well with the staff present, who kept asking them to switch to English because we're in England. Where are we? We're hearing that at the moment. And despite the customer explaining that, there's a reason why he's talking like that. His wife can't speak English well. He was treated aggressively and rudely and not even offered a handshake on the conclusion of the sale. The judge ruled that John Mulholland Motors staff had created a degrading and humiliating environment, which is why the judge ultimately ruled in the couple's favour. And if you look at the bit on harassment, which is covered under Section 26 in the earlier slide, some of the descriptions around what brings in a case of harassment. This was referenced by the judge in this case, and it's obvious that the behaviour of the car sales staff was completely unacceptable, and race was the determining factor. So, just going back to the slide here, there's always a bit of a discussion around positive discrimination versus positive action, and just to be very clear on this. Positive discrimination is unlawful. Employers are not permitted to carry out positive discrimination. There can be and are many positive action plans to, for example, to recruit people who are underrepresented in a company. There's one exception to this, and it's called a GOR, Genuine Occupational Requirement. And just so you understand what that means, let's give you an example of an Asian woman's shelter. If they had to recruit someone, they would be able to justify the genuine occupational need and requirement to recruit a woman from an Asian background to work in that Asian woman's shelter. So that's what's known as a GOR. So one of the points I want to finish on is for a person of colour. It's obvious to me that whilst race aspects of the Equality Act are designed to offer support and stop discrimination in the workplace, the reality is very different. We know that. Work applications are becoming anonymised more and more, which is definitely best practice. But when a person gets shortlisted and they get called to an interview, as a good friend told me, when you walk through the door and they see colour of your skin, there's no hiding, and prejudices will come into play. We know that. But how do you prove this? It's really hard. And unless something is said in the interview, you really will find it difficult to have an angle to demonstrate proof, or to put, for the burden of proof to be met. I touched quickly on the harassment. I think I want you all to make a note of this because this is the most common complaint that goes to Employment Tribunal. It's Section 26 of the Equality Act. And for those of you who have done our Equality Act on disability, the terminology is very clear. It's like what the judge said in the case of Mr. Wong buying a car. If you're placed in an environment which is degrading, offensive, you're being isolated, if you're being treated in a manner which is humiliating, this can all amount to an act of an act of harassment if the basis for that treatment is linked to your race. And Section 27 covers victimization. Quite simply, victimization is if you do a protected act, which can be if you take out a grievance or you make a complaint, and it's linked to race, because we're talking about race, and then you find you're treated less favorably on the back of making that complaint, which is known as a protected act. You could make a claim for victimization. So that's Section 27. So, friends, that concludes this whistle-stop tour of the Equality Act, looking at it in the context of race. This is the third in our series of bite-sized sessions linked to the 60th anniversary of the Race Relations Act. And we covered the first one, which brought in a bit of context around why the Act came into place. Phil did the second one just last week, focusing on black disputes, which focused on black activists and black organising. And the last one that we're doing next Thursday is actually in person at our National Equality event in Bournemouth. And our good friend Amarjeet Singh and Phil will be delivering that one. So I'm gonna leave my bits there, and as usual, we open the session to the floor. Over to yourselves if anyone's got any questions or any observations that they want to share. So over to you. I'll stop sharing as well. Mark.
Thanks, Fez, for that. I mean, it's a very good presentation. Also, we got to remember that our members in Northern Ireland are covered under the Disability Discrimination Act. So, obviously, can they still have the same level? I know it's individual, not as a collective. And the last one, you talk about the different ethnic groups. What happens if, for example, a Jewish white against a Jewish black person or brown? Are they able to take any action? And if it, as you see at the moment, there's a lot of tension between some of the Muslim Sunni Shia, uh, are they able to take any action even though they are part of the, you could say, the same group? Thanks, Chair. Thanks, Liz.
Yeah, thanks, Mark. Good questions. Before I respond to you, I just wonder if there's any other questions, and I can group them all together. Okay. If you think of something, just come in. Mark, on Northern Ireland, obviously there's you're right on disability. They've still got the Disability Discrimination Act. And on issues around race, they also have slightly different legislation around fair employment. And because there's obviously sectarianism aspects where people have to be protected in the workplace. So there are different legal provisions in Northern Ireland. And I think that there's something definitely worth doing. And I know it's something that we've spoken to Paul Newsham, and we're looking to do something similar for our reps and members who are working in Northern Ireland. The point you make around if someone is, the examples that you gave, we know there's interracial racial conflict. Racism isn't just a black and white thing. You know, there's interracial rivalry within the West Indies between the different islands. You know, there's significant different inter ethnic conflicts that are going on around the world, which play out here in the UK. So, you know, if a person is treated less favorably, you know, just talk about Section 26 for argument's sake. You know, if someone who's from a particular ethnic group, you know, who falls into that protected characteristic is abusive to a fellow person from a different race, then that, in my experience, that will be regarded as an act of harassment within the Equality Act. It doesn't, you know, there's no kind of immunity from that. You would still be, you still have to be, you know, respect the principle of the Equality Act when it comes to race discrimination. You know, there's no immunity there. So if there's people from different ethnic groups, you'd still expect them to behave in a way where dignity and respect is at the heart of relationships in the workplace. I hope that answered your question. Yeah, go on.
No, I was going to say because I'm talking about from the same group, not from a different group. So you both follow the same faith, you both have the same characteristic, but would a tribunal be able to legislate that you're insulting yourself at the same time?
Well, I mean, that would be unlikely to fall within the context of the Equality Act, if they are from exactly the same ethnic groups. You know, so that's my understanding. But I would certainly double check and come back to you on that. Fortunately, that's not a situation that we see very often, and the proof is in the pudding. We don't really see those types of cases going to employment tribunal, which backs up the point that I've made. Has anyone else got any other observations on this third bite-sized session before we wind up? I know it's gone 6:30, and when most of us have been at work.
Can I just ask a quick question?
Sure, Phil.
You mentioned about job interviews and racial bias during job interviews. Do you know of any case history of when that's been picked up or challenged, or of any kind of best practice for avoiding it?
I think there's more and more employers that are now moving towards anonymized applications. So personal details are completely removed. So it's purely down to the experience of the individual and their qualifications, which is definitely the right thing to do, because we know there's been social experiments where a person has applied for jobs in their name, which is typically kind of ethnic name, and then they've applied for the same job in an anglicized name, and they've been shortlisted with exactly the same details, which shows a clear racial bias by that employer. And those individuals have taken their cases, have sued those employers. Obviously, those ones were settled fairly quickly because the employer knew they were quite bang to rights on that. But look, people aren't naive to know. That's why I made the point, that whilst these practices are definitely a step in the right direction, if there's prejudice at play, it's actually going to be quite hard to see it because it's very rare that people are very overt with it. And when a person steps through the door and they have a very anglicized name, and if they're black, it's going to be really hard unless they apply for some kind of disclosure. They know that they're well qualified for the job, and they meet all the criteria. If it was me, I would be saying, I'd be writing to the employer and saying, look, I don't think you've treated me fairly. I want disclosure on how my credentials have stacked up against the person that you've appointed. And that puts the cat amongst the pigeons. So, that in terms of tactical approaches, that's something that people should consider if they've ever been put in that situation.
Well, thank you.
Right. No worries. Thanks for the question, Phil. All right. If there's no other questions, we'll close this third bite-sized session. Thank you to everyone who's come on. Genuinely appreciated. I know it's been a long day for many people, but you can switch off and relax now. So thanks, everyone. Take care.
Thanks,
Bye.
everyone. Bye.